From a government efficiency perspective, anyone interested can email her directly. Come talk to me if you want to get her email. The Federalist Society is a group of conservative and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom and that the separation of governmental powers is central to our Constitution. Here at SCU Law, our chapter seeks to bring balanced discussions and diversity of thought to our campus community. The format of today's event will begin with our invited guest, Mr. Josh Blackman, speaking to the forum, followed by our very own Professor Gula Sakram providing commentary. We will finish with Q&A. The event officially ends at 1, but we have the room until 1:30, so you guys are all welcome to stay and continue to ask questions. Josh Blackman is an associate professor of law at South Texas College of Law in Houston, specializing in constitutional law, the United States Supreme Court, and the intersection of law and technology. In addition to authoring several critically acclaimed books, Josh has written over 36 law review articles, and his commentary has appeared in many national publications. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy and has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and healthcare. Most of you guys already know Professor Gula Sakram. He joined Santa Clara in 2007. He has a BA from Brown University and a JD from Stanford, and he teaches constitutional law and immigration law here. All right, I'll turn it over to our speaker.
Thank you.
Yes.
Thank you so much. I have a special fondness for Santa Clara. My very first published article ever was in the Santa Clara Law Review. Back when I was a 3L, I wrote an article on this new thing called Google Street View. No one heard of it yet. And you guys published it, so I'm actually very, very grateful to give my first publication. I'm grateful to talk about the constitutionality of President Trump's travel ban. But before I get to that case, I want to talk about another case which you may have studied in constitutional law. This is the case of Texas versus Johnson. This case considered whether a person could be arrested for burning an American flag at a political protest. The decision broke down on 4 lines, but to the surprise of many, it was Justice Scalia that cast a tie-breaking vote for the flag burner. Now, Scalia was no fan of flag burners. He once said, quote, "If it were up to me, I would put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag." But Scalia said, "I am not a king." Indeed, Scalia felt the answer was compelled by the Constitution and the First Amendment, even though he disagreed with the results. Texas versus Johnson is a good gut check for lawyers and law students. If your understanding of constitutional law overlaps entirely with your own philosophical beliefs, you may want to reassess the former. That is much how I feel about the travel ban. I'm a libertarian, and I generally favor open immigration policies. I think they give banning people based on their country of origin, merely because those countries have been associated with terrorism, is an awful policy. These executive orders will cause hardship to families, refugees, and those seeking a better way of life. I am also doubtful that this policy would do much to improve our national security. Okay? My cards are on the table. I am firmly convinced that Congress gave the president the power to take these actions, and the Constitution does not bar him from exercising the powers in the manner in which he did. Need something here?
We get the forks.
Out of forks.
Oh.
Enjoy it. My talk will fork into 5 parts, as you would. First, I will walk you through the history of the travel ban, including statements made by then-candidate Trump, as well as now President Trump. Second, I want to discuss the contents of the 3 executive orders which have been halted by the courts. Third, I want to discuss whether the Congress has given the President the authority to take these actions from a separation of powers perspective. Fourth, I will discuss whether these actions conflict with the First Amendment, namely the Establishment Clause. Finally, I will give you a preview of the Supreme Court's upcoming argument in the case of Hawaii versus Trump. So our story begins way back in December 2015. Then candidate Trump called for, quote, a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what is going on. Those are his words. Over the next few months, Trump shifted his position, or did he? And he moved towards extreme vetting of people from certain territories. Cue PolitiFact, right? What did he actually say? On an interview on 60 Minutes in July 2016, Trump told Leslie Stahl, she can call whatever she wants, but we'll call it territories, okay? Was it an actual repudiation, or was it a wink and a nod to the alt-right? A week later on Meet the Press, Trump seemed to repudiate his statement, saying, I'm talking territory instead of Muslim. That's not a complete sentence. Often we have to parse Trump's thoughts, which are not always coherent. Now, what did he mean? The burden to decide what these statements mean has fallen to federal courts. And the federal courts have said, we figured out what Trump actually means. How? Because of Rudy Giuliani. You see, when Rudy Giuliani was on Fox News, he said, well, Trump told me, do it legally. Did he want to do the Muslim policy legally, or did he want to do a territories policy legally? We don't know. But the courts have said, this is a connection of animus and bias. This brings us to the inauguration. January 20th of 2017, Trump took the oath. Roughly 1 week later, he signed the first iteration of the travel ban. I'll call it 1.0 to keep it simple. Okay? It stated, for 90 days, certain aliens from Iraq, Iran, Libya, Somalia, Sudan, Syria, and Yemen were deemed, quote, detrimental to American interests. We denied entry. For 120 days, the refugee program would be suspended. Syrian refugees, in particular, we denied indefinitely. Now, almost immediately after this first order was signed, chaos erupted. Airport officials began to detain nationals of these 7 countries. I'm sure it happened at SFO very close by. Imagine, you get in a plane, your papers are in order. While you're in the air, this executive order is signed. When you land, they're not in order anymore. So people are being detained. And you may not know this, but when you land at the airport, until you clear customs, you are not on U.S. soil. You're not yet on U.S. soil. So you're actually detained in a holding cell without counsel inside the airport. Judges immediately freed people who were stuck in these holding cells. And additionally, a court in Washington, a federal district court in Washington, issued a nationwide, actually a global injunction barring enforcement of this version 1.0. The Ninth Circuit appealed. En banc review was denied. Trump did not appeal the version 1.0 to the Supreme Court. He said, let's start over again. So in March 2016, he signed a second executive order. I'll call it 2.0, keeping it simple. There were some changes to this order. It removed Iraq from the list and also made clear that green card holders were not subject to the ban. It also shifted the focus. The first order suggests that these aliens themselves are dangerous. The second order said that no, the countries they're from do not share adequate information with the United States, and we don't have adequate cooperation. That is why the policy was implemented. Surprise, surprise, once again, it was challenged in federal court in Hawaii, in Washington, in Maryland, in various places. Again, district court judge in Hawaii issued a nationwide injunction. A district judge in Maryland issued a nationwide injunction. Both the Ninth Circuit and the Fourth Circuit affirmed. This time it goes to the Supreme Court on what's called an application for a stay. In the first sign that perhaps the lower courts were not getting it right, the Supreme Court issued a partial stay, not a complete stay, but they said if you don't have any sort of close bona fide relations, you can be subject to this ban. Well, I'm not going to get into what bona fide means, but certain people who were allowed to enter in the Ninth Circuit ruling were now being denied entry. Okay? But this second policy, 2.0, was only temporary. It was designed to last for 90 days. After 90 days were up, we come to, you guessed it, 3.0. It's actually called a proclamation. There was no executive order, but I'll call it 3.0 to make it easy. On September 24th, President Trump issued the third iteration of his policy. This new policy identified 2 additional countries who were on it, which was basically North Korea and Venezuela. Now, you might guess North Korea doesn't send very many immigrants to the U.S., and for Venezuela, it affected a fairly small number of diplomats. So it basically is a wash. Now Chad was added, so we have one additional predominantly Muslim country. We're basically in the same space in terms of demographics. But the difference with this policy is that it was not an interim policy, right? It would basically go on, perhaps indefinitely, though there is a review provision that every 6 months they review it. Also, this was adopted after a fairly lengthy review by the U.S. government about our relations with different countries. Okay. This policy, once again, was challenged in court. See, sensing a pattern, right? A federal judge in Hawaii, a federal judge in Maryland, same judges, issued global injunctions barring the enforcement of these orders on different grounds. Went up to the Courts of Appeals. The Ninth Circuit issued a ruling on statutory grounds, saying that this is a violation of the Immigration Act. And the Fourth Circuit issued a constitutional ruling. This violates the Establishment Clause of the First Amendment. Goes to the Supreme Court one more time. Here the court did something a little bit different. In the past, they let part of the ban go into effect. This time, they let the entire thing go into effect. So as it stands now, for at least, the past 2-3 months, the entire travel ban has been in effect. It's been in effect now for months. Now, my crystal ball is very cracked up. But as a general matter, when the court lets a policy go into effect, that's a pretty good signal to uphold at the end. Doesn't happen all the time, but in almost every case where the Roberts Court allows a policy to go into effect, at least temporarily, it's upheld. Take it for what you will. Supreme Court granted certiorari, and arguments will be upheld April 25th. I will be there. God will only get a seat, but I will be there. Okay. With that background in hand, let me move on to the third part of my talk. Does the president have the statutory authority? Did you have the statutes appear?
I couldn't get it up.
Okay, it's fine. Okay, so I'll read them. Okay, so there are two statutes here we've got to be talking about. Okay, the first is 8 U.S.C. 1182F, enacted in the 1950s. Let me read this to you. It says, whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may, by proclamation, and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of any aliens any restrictions he may deem to be appropriate. Okay. So the rub of this is if the president determines that an alien or group of aliens is detrimental to American interests, he can suspend their entry. I think, Josh, isn't that the ball game, right? Doesn't that give you everything you need to know, right? So the courts of appeals have looked at the statute as, no, you can't read it that broadly, right? So some courts have said the president must make specific findings about why one given alien or class of aliens is detrimental. Other courts said, well, this can't be indefinite. There has to be some period, as he shall deem necessary. It can't go on and on and on. These arguments are fun and nice. They're not going to win at the Supreme Court. Because there's a case which has been really grappled with called Shaughnessy versus Konami, or Konami-Shaughnessy, always flip it. This is the case in the 1950s where a plurality of the court, as a 4-justice majority, explained that the president has an inherent Article II power, to deny entry. That is, even if Congress had not enacted a statute, I think the case would probably come out the same way. But that Congress did enact the statute means you have the president's inherent power, Article II, and a delegation of power from Congress, Article I. He is at the apex of his authority. This is what Justice Jackson referred to as the first tier in Youngstown, where court scrutiny should be minimal. And you have examples of President Carter and President Reagan using this to deny entry to Haitians and Iranians and Cubans and various other groups. So you have precedent. So this statute, I think the court's going to have a very tough time narrowing to go to the constitutional question. There's a second statute, though, which I think the president has a lot more trouble with. This was a provision enacted a couple of decades later, in the 1960s, as part of the big Immigration and Nationality Act. This was a really important piece of legislation in that it abandoned the old quota system, right? As our immigration laws used to work, if you were from a desired country, you'd get a visa. And if you were from a not-so-desirable country, you'd be put on the back burner, right? You'd have to wait. The INA, the Immigration and Nationality Act, abandoned that visa quota system. And they enacted a provision, right? And this is Section 1152. And it says, quote, I'll read it to you. no person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa because of the person's race, sex, nationality, place of birth, or place of residence. So that's an important statute, that when you're issuing immigrant visas, you can't discriminate on the basis of nationality. As a threshold matter, this only applies to immigrant visas. It doesn't apply to non-immigrant visas, like tourist visas and the like, right? So this is only an immigrant visa, a fairly small subset, or not small, but the subset of visas that can be issued. Notice, it doesn't mention religion. It says race, sex, nationality, place of birth, place of residence. It doesn't mention religion. I'll come back to that later. So you say, Josh, but isn't this obviously discrimination? Well, let's just be careful. The entry ban does a couple things. It suspends entry, right? That is different than the issuance of a visa. And I've been making this point now for well over a year now. There's a difference between whether a person can enter or whether a person has a visa being issued to them, right? Say you show up at the airport, you have a valid visa, and it turns out you have Ebola. Guess what? You're not coming in, right? Say you have a valid visa. You show up at the airport, and you start lying to the consular officer. He senses you're lying. You're not coming in. Merely having a visa is separate from entry. And so I think these are different concepts, right? But let's say I'm wrong about this, right? Let's say that indeed the travel ban is affecting the issuance of visas, which I think it might not. The next paragraph, right, paragraph B in the statute says, nothing in this paragraph shall be construed to limit the Secretary of State to determine the procedures for the processing of immigrant visas or the locations where such applications will be processed. There's an exception that the Secretary can consider nationality when they're determining, quote, the procedures for processing of immigrant visas. This is where I think the court saves Trump. I think this is going to be at this one paragraph. If you read the statute as the challengers suspect, the president has very limited powers. So imagine we declare war tomorrow with Germany, right? Can the president deny visas to Germans on the basis of their nationality? Do we really want to read the INA and say the president's required to give visas to a foreign belligerent? I don't think that's right. I don't think that's possibly the answer. So the hook has to be paragraph B, which says you can determine procedures for issuing visas that consider nationality. It's not the best reading of the statute, but in this realm we often have what are called saving constructions. And this, I think, how the court will save it. Maybe I'm right, maybe I'm wrong, but I think, mark my words, paragraph B plays a role in the court's opinion. Okay. That's the statutory angle. Okay? Let's say I'm wrong about everything, right? Let's say that the statute, let's say I'm right. The statute gives Trump this power, and this immigration discrimination provision doesn't apply. You still have the Constitution. If Trump is violating the Constitution, it doesn't matter what the statute says because the Constitution trumps. Not intended, right? The Constitution is the supreme law of the land. So the argument here is that President Trump's travel ban violates the Establishment Clause. Why? Because it shows a animus or a disfavor of Islam, and maybe even a preference for Christianity, depending how you frame the issue. Okay? Under Supreme Court case law, the government can't show a preference or a disfavor for any given religion. That's pretty well established case law. But there's a threshold question, which I've been writing about for a year. And the question is this: does our domestic Establishment Clause case law even apply in the context of immigration? Right? In other words, can we simply import our case law, domestic, right, into the foreign policy context? The answer is not so simple. It's not, of course you can. But I'll give you a couple examples. We have certain statutes on the books that are very old that are very much unconstitutional if you apply domestic case law. Let me give you an example. There are lots of visas, right? One type of visa is for ministers. If you are a minister, you qualify for a special type of visa. You can get to the U.S. much quicker than otherwise. Now, what's a minister? Aha. The regulations define a minister as someone with a lifelong vocation, like a priest or a mother or a nun or a monk. The regs specifically spell out the types of religious officiants that will get it. Let's say you're a minister in some sort of part-time religious affiliation. you're not getting it. It's for full-time vocations. And there's actually a lot of litigation over this. Now, if those are domestic statutes and we're giving benefits only to people with certain types of religious structures, oh, that'd be done in 5 seconds. No one has ever challenged this as unconstitutional. I've looked, hasn't happened. Another more recent provision is called the Lautenberg Amendment. What is a Lautenberg Amendment? It provides, this was during the Soviet Union, by the way, that any Soviet Jews or evangelical Christians get a certain benefit when applying for refugee status, right? In other words, if you're a Buddhist living in the Soviet Union, you get nothing. If you're a Muslim living in the Soviet Union, you get nothing. But if you're a Jew, or it says a Jewish person, or an evangelical Christian, it says in the statute, you get preferences. My God, right? If that was a domestic statute, it would be tossed in 5 seconds. It's been in the books for decades, no one's ever challenged it. In fact, there's very little in immigration case law saying that the Establishment Clause applies, right? This is something for our community. The entire basis of refugee law, of asylum law, involves entangling yourself with religion. Is this fear of persecution credible? Does he actually believe this? What are the contours of the faith? You get into some very thorny issues that would not fly in domestic court. So I humbly submit, and maybe I'm wrong, maybe I'm right, that the Establishment Clause just does not apply in the immigration context. And the lower courts have ignored this. They've ignored me. That's fine. They can ignore me. The Supreme Court can't. Because if you inject the First Amendment into immigration law, you open up a lot of messy stuff, right? People can challenge these very provisions. I think ultimately it will result in less people gaining status, which might not be what you actually want. But I think ultimately the court will hold that the First Amendment just has no bearing here. That obviates the very difficult question of how to read the president's tweets and animus and Rudy Giuliani. The Supreme Court's not going to be citing tweets. I love this. It's awesome. It's fantastic. It's fun to read. And I wake up every morning, oh, what a Trump tweet, right? That's not going to be the basis of the Supreme Court's decision. And this brings me to my final point. We're dealing here with the Supreme Court, not a court of appeals. And there's a very, very big difference between these institutions, right? When a court of appeals makes a decision, we'll read the opinion, but it's not going to wind up in your casebook, right? If you open up your common law casebook and you flip through, how many court of appeals decisions are there in there? 1, maybe 2? I think I have one in mind, right? People remember the U.S. Supreme Court decision. These are read for decades to come. And whatever constraints are put on presidential power here will apply not just to President Trump, right, to President Elizabeth Warren, right, President Malia Obama, right, whoever it is, right? You have these constraints are beyond the books for a very long time. The courts of appeals have not given the president the authority and deference that he is due. Now, again, I'm not a Trump fan. I'm not. Right? I'm not. I don't like what he does. But he's still the president. And the courts have not treated him favorably. And the fact that the Supreme Court granted the stay, right? I mentioned this. They put the entire ban into effect. Signals that at least the majority of the judges on the court are not in agreement with the lower court. If they were, they would have put the entire thing on hold, right? This was the next Korematsu, put the entire thing on hold. They've let it go into effect. They've already told us what's going to happen, right? That's why a lot of the commentaries have just kind of pettered out to know what's going to happen. I've been on this since day one. So I think ultimately the court does uphold the travel ban. They might have some dicta, right? Some extended discussions of why the president's statements are troubling, but in this context of foreign policy, they're not relevant. See, that opens the door for using it in domestic context, right? Domestically, I think the president's tweets are actually fair game. I don't have a problem with it. But in foreign policy, it's not a sort of strict scrutiny that applies. It's a rational basis review that applies. And I'm going to go on a leg. I don't think this is 5-4. I think this actually might get 6 or 7 votes. Perhaps a little more narrow. But I think at least Justice Breyer and Kagan recognize the significance of the lower court rulings and why they don't stand. But again, I admit this case is close, right? The president is his own worst enemy, and he always says and does things that make his case harder and harder for his lawyers to defend, which is unfortunate. I wish this policy were repealed tomorrow, but that's not my call. All I can say is I think this policy will be upheld by the court come the end of June. Thank you so much, and I'll serve my good friend Deep, who can provide a different perspective. Thank you.
Cool.
Do you need your phone?
That's fine.
Okay.
Whoa.
Okay. So thank you for having me. Not surprisingly, I don't read the statute the same way Professor Blackman does, and I'll let you know why it is that I don't read it that way. I'll leave this up here for now. It might go to screensaver or something, but it'll be useful when I get to that spot. Okay, so let's see where to start. So I don't think, let's just say this as a sort of an introduction and a way of starting a response to Professor Blackman's presentation. I don't think there's only one way to read the statutes and these statutes, and I personally don't find Professor Blackman's reading to be the most persuasive way of understanding these background statutes. Fundamentally, I don't think that the way in which Professor Blackman reads them is actually can make sense in light of the entire INA and its history. So I thank you, by the way, Josh, for that, the history of the executive orders and proclamation, as well as the larger context in which they're being enacted. I think it's worth noting, and this gets to partly how I would read these statutes, that in the 1880s, with the first immigration laws, those were in fact based on national origin and race expressly. That is, the first federal immigration laws were the Chinese Exclusion Acts, which did exactly as their name sounds. They excluded the Chinese, particularly, from immigrating to the United States based on their national origin and their race. That was later expanded by the late 1800s and the early 1900s to the entirety of Asia. Japanese immigrants, Filipino immigrants, all areas of Asia, including the Indian subcontinent, were barred from immigration into the United States. This was followed in 1921 by what Professor Blackman alluded to as the National Origins Quota Act, a sanitized way of creating a law that essentially said that the only people allowed to immigrate into the United States were going to be those from Northern and Western Europe, those that reflected at that point the majority demographic and the desired demographic of lawmakers in the United States. The visas that were left over for countries that were not Northern and Western European were, one, extremely small in size, so trivial as to not really make any impact on immigration, and to the extent they covered Asia, were actually not usable by Asian immigrants from Asia. They were only usable by European or other immigrants who happened to be in Asia and applying from those countries. So from 1921 to 1965, United States immigration law reached its lowest levels of immigration in United States history and reflected the demographic preference of the lawmakers in 1921 and 1924, who only really wanted Anglo-Saxon, mostly Christian immigrants into this country. It was in 1965 that the United States, as Josh alluded to, completely reformed its immigration laws and finally repealed national origin quotas, finally repealed the Asiatic barred zone, and opened up immigration to the entirety of the world. The reason that background is critical in trying to understand the statutory background for this particular debate or this particular discussion is because it is in 1965 that the provision that Josh alluded to, 8 U.S.C. 1152, the non-discrimination provision, was put into place as part of the general desire of Congress not to discriminate on the basis of national origin and to change our immigration system to reflect a family-based, family reunification focus in the issuance of immigrant visas. These are the two provisions that Josh pointed to. First is the non-discrimination provision, as you see. No person shall receive any preference or priority or be discriminated against in the issuance of an immigrant visa. And then gives you the bases. Religion is not one of them, but nationality and place of birth are. Second is the provision that Josh argues is going to somehow save the proclamation and potentially factor significantly into the Supreme Court's ruling, and that is the provision that allows the Secretary of State to create procedures. I'll get to why I'm not convinced that that's going to be, I'm not even convinced the Supreme Court will address that provision, let alone it be the basis upon which it decides the case. But before we get there, the prior provision that the president himself cited to as giving authority to create the proclamation and the executive orders that preceded it is a section 8 U.S.C. 1182F, suspension or entry of imposition of restrictions by the president. Worth noting that this provision was, as Josh pointed out, enacted in 1952. So it predated the 1965 amendment, the Non-Discrimination Provision, by 13 years, was enacted during the time, this was enacted during the time of national origin quotas, where the United States expressly excluded people on the basis of where they were born, had the Asiatic barred zone, and generally was comfortable with the notion that people could be restricted on the basis of where they were coming from. But I will, as Josh suggests, this is an extremely broad delegation of power by Congress to the president. Perhaps the broadest delegation of power by Congress to the president you can find anywhere in the United States Code, or at least I have not found one yet that speaks to this large of a delegation of power. Then one might argue, based on this, as Josh does, that this fits directly into the Youngstown Steel framework. For those of you who remember Con Law 1, the framework where the court says when the president is acting with the express approval and acquiescence of Congress, that is when the president is acting with the greatest amount of power in Category 1 of Youngstown, Justice Jackson's iconic opinion in that case, and therefore the presumption of constitutionality applies. My own view is that Youngstown is really a bit of a red herring here, and likely, in my view, in my reading, mostly irrelevant to the discussion that as to how best to read this statute or whether the proclamation is constitutional. The reason I say that is because nothing in Youngstown allows the president, or Congress for that matter, to enact or create proclamations, create law, create policy that is unlawful or unconstitutional. That is to say, Youngstown presumes that what Congress is allowing the president to do is both within Congress's power and within the power of the president. The claims here by the challengers in the travel ban case are that the proclamation violates the Fifth Amendment to the United States Constitution, which applies directly to Congress, as well as the First Amendment to the United States Constitution, also a restriction on federal power, and specifically, as originally written, a restriction on Congress's power to violate the Establishment Clause. That is to say, Congress is not authorized to create laws that have religious preferences or to violate the Due Process Clause of the Fifth Amendment, and therefore Congress cannot authorize the president to do either of those things either. So in my view, it's not clear that Youngstown really adds a significant amount to the discussion of the constitutionality of its ban, especially given that these are the exact claims that the challengers are making. My view on the statutory analysis is that there are two sort of responses to Professor Blackman's reading that I think that at least are more convincing to me. I take Professor Blackman's point that whatever it is that I'm about to tell you may not be, if we're just reading tea leaves and counting noses on the Supreme Court, may or may not be what 5 justices are convinced by. In my view, that doesn't tell us anything about whether, or tells us very little about what the best reading of the statute is, or what complies more with a holistic understanding of the INA and our fundamental values in the Constitution. It does, of course, tell us what 5 justices of the Supreme Court are willing to accept, and will presumably tell us what the end result of this policy is going to be, whether it goes into effect or not. So I won't spend my time here attempting to prognosticate. Josh Blackman is a known prognosticator on the Supreme Court, so I'll leave the prognostications to him. But my view on the statutory analysis comes down to 2 points, which I'll try and make very quickly. One is that Professor Blackman's reading leads to an absurdity in the reading of the statute, and that 2, the contextual history of 212F suggests that it also cannot be read as broadly as Professor Blackman would read it. Let me start with the absurdity point, which I will break down into 2 forms of absurdity if you read it, I think, as broadly as President Trump would like to have it read. The first is a very simple one. That is, if the INA, in one of its provisions, 212F, by the way, I should note, this section is a part of a larger statute, 1182, which is about all the things that Congress wrote that make somebody inadmissible to the United States. So it lists all the classes of people who can't come in, including people who are indigent, people who have committed several crimes, people who have terrorism concerns in their background, people who are foreign policy concerns for admission to the United States. That is to say, this is part of a statute that already lists several reasons why somebody would not be allowed to come into the United States, including the fact that they might be a security or terrorism threat to the United States. So let me start with my first absurdity point, and that is, if one reads this literally, this delegation literally, it is the power of the president to completely, on his own power and own accord, rewrite the entire INA. That is to say that this power allows the president to decide that all the limitations that Congress has created for how many visas can be issued in a given year, to what places, to what countries, to what individuals, can be thrown out the window. It strikes me that that is not the proper way to read a statute, or that the statute must be read in light of its potential consequences, at least with regards to the other parts of the INA. And it doesn't strike me as quite as convincing that what Congress was doing here was allowing the president to essentially rewrite all the other restrictions and possibilities within the INA. Second, I think that it is, while Professor Blackman is right, that technically this provision deals with entry, and the non-discrimination provision I showed you before deals with the issuance of a visa. And so Professor Blackman finds daylight between these two things, the issuance of a visa and entry into the country. My suggestion is that they cannot be so separated, that it in fact makes no sense to separate those two things in the way, because the issuance of a visa is so related to entry that they have, even by this president, have been treated as essentially the same thing. If you look at the executive orders, they speak about entry bans. They don't speak about issuance of visa bans. Moreover, it's not clear to me that the example that Professor Blackman cites about somebody with Ebola coming to the country who may have been issued a visa but could still be denied entry really solves the problem. I'd note just as an initial matter that there is no statutory prohibition on discriminating against people who have Ebola. And it is true that immigration officials, when somebody lands at an airport, can make a de novo interpretation, a de novo assessment of whether this person is fit to come into the country. However, what they cannot do is impose new requirements for that person to enter the country. They can consider the evidence that a consular officer may not have considered in the first place, but they are not fundamentally changing the requirements for entry when the person comes and lands at an airport. Professor Blackman's reading would allow for sort of this Kafka-esque situation where somebody lands at an airport with a valid visa, but can then be prohibited from entry and therefore, like Tom Hanks in The Terminal, spend significant amounts of time just living in the airport. By the way, I use that reference because the Ninth Circuit, in oral argument for on the second executive order, in fact brought up that example where one of the judges in the
You're
Ninth
responding
Circuit,
to me.
one of the judges in the Ninth Circuit said, so is this like that movie, that Tom Hanks movie, right? Referencing the terminal. So I personally don't think that it makes much sense to find daylight between those two things. The State Department, I should add, once the first executive order was created with the entry ban, stopped issuing visas. Why? Because they also understood these two things as so closely related that it really doesn't make sense to differentiate between them. I would also add that this section, as I mentioned to you, was created in 1965, whereas 212, the broad power to the president talking about entry, was created in 1952. It very well could be that in 1952, entry and issuance of visa may have been distinct, who knows, but by 1965 and past that, these two things essentially mean the same thing, or so closely related that it doesn't strike me as sensible to have daylight between them for purposes of determining whether both provisions, whether 212F can withstand the non-discrimination provision that enacted in 1965. Getting to my historical context point then, which I've already foreshadowed, simply that the president's power, as understood by Congress in its 212F, in creation of 212F in 1952, must be read, I think, by principles of everyday statutory analysis to be bound by the 1965 non-discrimination provision, at least as it applies to immigrant visas. I think there's a tougher argument to be made that this non-discrimination provision could also apply to non-immigrant visas. For those of you who have not taken immigration law, this is a term of art distinction. Immigrant visas are those issued to people coming in as legal permanent residents, in other words, green card holders, people who have essentially a right to remain in the United States and work in the United States so long as they don't violate the conduct rules in the deportation laws. Non-immigrant visas are visas issued to people who are lawfully in the United States but are coming for a limited purpose or for limited duration. So as Josh mentioned, tourists, but also people like H-1B holders, other people coming for temporary work or stay in the United States. That's a non-immigrant visa. So it is entirely possible that the non-discrimination provision might only apply to immigrant visas, but important to note that the proclamation applies to immigrant visas. It is a ban on entry of anybody under any visa status from the countries that Professor Blackman mentioned. So at least as to those immigrant visas, and those are mostly people who have family in the United States who are applying for them to come as spouses, children, brothers, sisters, with those family relationships, parents, those would be the people barred by the proclamation, and those are the exact people to whom this non-discrimination provision is speaking. You don't need religion to be the basis of the denial, because the denial here is working, at least on its face, on the basis of national origin. It uses national origin as a stand-in for threat and national security. So that is my version of what I think is a much more persuasive reading of both the contextual history of the 212F provision as compared to the non-discrimination provision, and what I think are the nonsensical or absurd sort of consequences that you get from reading the 212F to be as broad as the president would like to have it read. I'll finish by saying, since Professor Blackman brought it up, one might look at the Korematsu case, right? It's an important case in national security. The lesson I would draw from Korematsu is that we should be, that case was, the provision allowing the internment of Japanese was upheld by the Supreme Court. Korematsu has never been formally overruled, although the United States issued an apology for its internment of mostly Japanese citizens, Japanese American citizens of the United States in internment camps for up to 4 or 5 years, where their property was taken away and they were held against their will and without any due process, and with 0 people being convicted or even charged with any crimes related to treason. I would suggest that what Korematsu tells us is that when national security acts as a facade or a cover for supposed concerns with individuals, that is exactly the situation where we should be quite concerned about the invidious racial discrimination or religious discrimination that might be operating underneath that facade of national security. It is not a time or precedent that I would be eager to come back to, and I do think that courts, including the Supreme Court, might be quite wary of sanctioning and condoning the next Korematsu versus United States, and on that basis, I think might be much more circumspect about upholding the proclamation than Professor Blackman suggests. Thank you.
Thank you.
Do you want me to leave that up there?
In terms of class, if you need to go, just do it now. No one? Okay, good.
Do you want me to leave this up?
Yeah, leave it. That's fine. That's fine. I might check your email. No, that's okay. Thank you. You guys are very fortunate to have Professor Gulasekaram here. He's an expert on constitutional law, next immigration law. So it's an asset to have him here in Santa Clara. Oh, now you get up. Just it's fine. It's fine. If you need to go, it's fine. I'll make a few points in rebuttal. By the way, the Ninth Circuit was still responding to the terminal thing that I wrote about this months ago. But this case I want to read from, it's called Konami Shaughnessy. I'll read this passage and I'll go to Q&A. The court said, the exclusion of aliens is a fundamental act of sovereignty. The right to do so stems not alone from legislative power, but is inherent in the executive power to control the foreign affairs of the nation. When Congress prescribes a procedure concerning the admissibility of aliens, it is not dealing alone with the legislative power. It is implementing an inherent executive power. Not a single one of the courts who has enjoined the proclamation bothered to cite that language. One concurring opinion did, and he totally read out of context. I'll explain why if you want afterwards. You can't read that and read the statute the way the challengers do. Now, maybe this is not good language. Maybe the court will overturn this case, Knopf. It's not a popular case, right? But I said this at the outset. If Congress had never enacted 1182F, the statute we have up here, right? If Congress had never enacted this, I think the case would turn out the same way. Congress's powers over naturalization, visas, that's where Congress exists. The president, though, has a power over admissibility in terms of entry, decision to enter in the country or not. At the border, you have executive branch officials, you don't have legislative officials. I think they're acting in their own power. So if I'm right about Article 2, and maybe I'm wrong, maybe I'm right, you have to read the statutes the way I do. I agree, it creates absurdities, right? It gives the power to the president to trump huge portions of the INA. I'm not going to argue with him. He's right about that. But again, Congress can't control an inherent executive power of this fashion. But there's no need to read it in that way. I provide a way I think accounts for all the text, and I think we'll provide the rule of decision. I'm going to stop there. We have a few minutes left. Do you want to respond or go to Q&A? What's your preference? Please, I welcome questions. Yes, sir. 1 and 2. Yeah.
Two things that you mentioned. I know when you first read the text that it says that it shall deem necessary. Because my question is just kind of going to the arbitrariness. Because then part of the example you said at the end was that the United States was doesn't want Germany. You would have no. I know the name was executive. You would say something. You don't want to get Germany with the whole thing. I'm not sure how that lines up with your argument because you're not sure what things
are we? Oh, AUMF. No. But this. Let me interrupt you. I've written about this. This is a serious issue. I am waiting for a judge to tell Justice of the Supreme Court, are we at war? And they go at the AUMF. That's a really tough question because it's against terrorism. But no,
that was kind of going to
yeah, it's a good question.
We have 140 countries, so why would it be deemed necessary? This seems almost arbitrary, which would go towards the point where it is a Muslim ban.
It's a very good question. Everyone understands this question, right? Is this phrase he deemed necessary dependent on the declaration of war? I say no. The court here describes as inherent executive power. The fact that it's inherent means it's not linked to a declaration of war. So even if there's no declaration of war, the president still has power, right? I think he still has power. But he does have the AUMF. He hasn't made this connection, and I think it might come up at oral arguments, but there's a very tough question. Does the AUMF reach ISIS?
So that isn't necessarily even part of this?
It's irrelevant, exactly. I think the statute's irrelevant. If Congress had never enacted 1182F, I think the case is going to be the exact same way. It's nice that Congress reaffirmed it's why you're in Zone 1 of Youngstown, right? The president has his own power, and Congress said, yeah, we're going to, whatever power we have, we're giving you also, which is why scrutiny is the minimum. I think it's a question there and a question there, and then a question there. So 1, 2, 3.
Yeah, so I'm sorry for being ignorant on the subject, but I don't know what the current process is for issuing visas to foreign people. Could anyone give us a rundown on that?
We have an expert in the House.
And what factors they consider, don't consider, stuff like that?
Sure. I mean, if you want to look, it's basically very simple. It's not simple to get in, but if you apply for a visa, you need to be in a category of people for which makes you eligible. That's of some sort of specified family relationship, or you have an employer in the United States who's willing to sponsor you. Assuming that you have that in line, then you apply for a visa, and then consular officers or the United States Citizenship and Immigration Services consider your application as against these groups or these requirements that Congress has set up. So you see right here, this is the beginning of that statute. It says classes of aliens ineligible, health-related grounds. So this is one of the grounds. So you would be forced to go to get a health screening by somebody approved by the Health and Human Services Agency of the United States. And if you pass that, that's one of the things that you get. And if you look down the statute, you'll find several other bases upon which and requirements that you have to meet. Assuming you meet all of those, the visa would be issued to you, and then you could show up. In most cases, you get the visa, you show up, and the person at the executive official at the airport lets you in. Technically, the executive official at the airport does have the opportunity to reconsider whether, in fact, you failed one of the health grounds, reconsider whether you failed one of the crime grounds, and deny you from getting into the country. Most cases, that does not happen. They're mostly just checking to see if your documents are in order, and then you get into the United States.
And then what's the average time between start to...
That is a complicated question. Depends on which country you're coming from. Depends on what type of relationship you have to the person in the United States who is applying for you. And then it finally comes also down to processing times and how long all of this background checking.
It could be years, right?
Oh, it could be. There are some visa categories to which the wait time is 24 years, so lifetime. And there are some for which you can apply and get in as fast as you can process the visa, which might be somewhere from 3 to 6 months.
Okay. Number 1, number 2.
Can you provide the updated list of countries on the U.S. ban?
Yeah.
All countries that we have.
Yeah. Give me a second.
It's Chad, Iran, Libya, Syria, Yemen, North Korea, Somalia. Then specific provisions for Iraq and Venezuela.
I think that's it. Yeah.
Iraq is not, it's a heightened screening. It's not a refusal to allow. And then Venezuela is non-immigrant visas for certain government officials.
Yeah,
it's a smaller group than the first group I mentioned.
Very good. Yes, sir.
Yeah, I was just going to say, even if we assume it's correct, isn't there this implied notion of good faith in that of the president? And if so, how do we reconcile that with his own statements and that of his administration?
Yeah, very good question. We didn't hear it. Is there an implied statement of good faith behalf of the president? Are you taking that from the take care clause? Is that what you're getting that from?
Well, just that he needs to find that it's, it would be detrimental to the United States if he were to admit them, or I forget the actual.
Yeah, here it is. I'll bring it up here, right? You scroll down. Right, so he shall deem it's detrimental to the interest of the United States, right? Your position, he's not acting in good faith when he finds detrimentality? Is that the...
Right.
Okay, so I take his point, and I said at the very beginning, I think this is going to do almost zero for our security. I'm going to be with you. I have to review this with a rational basis lens. And if you haven't taken common law, what that means is, so long as the government articulates a reason that could be valid, whether it's the right reason or not, of course we'll uphold it. I have to read it this way. If I start reading this statute, 1182F, with basically almost like a strict scrutiny lens, like is this malice, is this a cover, or is this a real reason? I'm wading into very treacherous grounds. Now, the lower courts have all said that there's no way that the reason is given is the actual reason. It's all anti-Muslim animus. We could give you whatever, right? I don't think that's the right standard view. Politically, right, as a matter of politics, Trump's folded. Right? This is not the reason why. But I think they put forward enough government review, enough documents, enough surveys, enough evidence to make this cross the finish line by a boatload. But look, you're not wrong. You're not wrong with that. Yes, in the back.
As somebody who does some speculation, it sounds like, on the Supreme Court, I was wondering if you could speculate on potentially a newest member of Gorsuch, where he would lean in this situation, or what past experience he has talking about some of these issues?
Yeah, does Gorsuch have any national security case? I mean, he worked in the Bush National Security Division. I don't know that he had any case in the 10th Circuit about this.
I don't recall any. I mean,
He's smiling.
I know, but I would assume that
Yeah,
he
so-
very much likes the guy who appointed him.
Well, so I'll give you a little easier one, right? He already voted earlier this year, back in it was June or July, to let the entire ban go into effect. And this was on an early iteration. So I can't speak of his background, but at least his opinions in the court suggest that he and Thomas and Alito think that this is just fine and dandy. One note, though, Justice Kennedy, of course, is our overlord. He decides who lives, who dies, who gets married, who doesn't. Right? He is our alpha and our omega. When Justice Kennedy allows a policy to go into effect, that is, he votes to grant a stay, he ultimately votes to reverse the lower court. So the fact that Kennedy let this go into effect is almost like, counting noses, dirty business, right? But it's a pretty good sign.
It is worth noting that the Ninth Circuit stayed its own order, right? So the Supreme Court wasn't necessarily telling the Ninth Circuit. It was only with regards to the Fourth Circuit.
Right.
So it could be that, I mean, I take your point, and I think it's a good one, or at least it's descriptively correct, that oftentimes when the Supreme Court chooses not to, allows it to go into effect, that they're tipping their hand. I will say, though, that the Ninth Circuit stopped its own order from going into effect pending the Supreme Court's rulings.
Wise move. Yeah.
Well,
No. The Ninth Circuit, by the way, I've complicated. Usually the Ninth Circuit is like they've been the grown-up in the room. They've been actually moving on the ball quickly. They've been issuing decisions quickly. The Fourth Circuit's been, it's not what it ain't what it used to be. Maybe one more question, we'll wrap up. Is that a scratch or a question? Anything else? No? Thank you all so much. I'm very grateful for your attention. If you have any questions, please come back afterwards.